Hi, today we cover ICOs in Switzerland. The ICO activities in Switzerland have been pretty hot the past couple of years. And so it's interesting to see what the regulation of ICOs today is. So basically we have these guidelines that the Swiss SEC called the FINMA issued in February. They put the tokens that are sold in an ICO in three different classes. A token can be an asset token, or it can be a payment token, or it can be a utility token. The FINMA also said that it's possible that there is like a hybrid token that has the characteristics of a payment token and an asset token. So let's talk about what a payment token is. A payment token can be used today or in the future as a means of payment. And anyone who provides payment services or issues or manages a means of payment is considered a financial intermediary that would be subject to anti-money laundering regulations. So what kind of payment tokens exist? So for instance, typical payment tokens are Bitcoin, Litecoin, Ripple, or also Dash. So let's go to the second category, the asset tokens. The asset tokens, they represent the debt or equity claim on the issuer. They are analogous to equities, bonds, and derivatives. They can confer ownership right, they can confer an equity interest, or a claim in a bankruptcy proceeding. And what kind of regulations apply to asset tokens? Asset tokens are considered securities, and securities regulations apply to these tokens. And what does that mean? Compared to the US, we don't have registration requirements in Switzerland. So you don't have to register your securities with the Swiss SEC, the FINMA. Also, if you offer these tokens publicly, the asset tokens publicly, you're subject to prospectus requirements. However, these requirements are a much lower standard than in the US or in the EU. For instance, the prospectus don't have to be approved by the FINMA. So what about the third token class, the utility tokens? They confer digital access rights to services or an application on a blockchain-based infrastructure. The FINMA said that no regulations apply to these utility tokens. However, they also said that if the utility token is not operational yet, it is treated basically as a security. So there is some ambiguity and some uncertainty that comes with that assessment, because basically it makes the classification of utility tokens redundant, as today most of the ICOs do not have an operational token. So it's questionable whether this classification of the FINMA will be backed by courts, or what kind of ICO regulations we will have in the future in Switzerland. So what's the bottom line? Switzerland remains an attractive place for ICOs, particularly also because we have a lower standard for the prospectus. We don't have registration requirement for securities. So yeah, we'll see what the future will bring. Thank you for watching. If you have any suggestions about videos in the future, please text, comment, email, and have a good day.